is not going to be testifying today?
No, we spoke about it. He's shaking his head. No, he's not going to testify.
Okay. And it's my understanding, Mr. Pervin, that you did have an opportunity to meet with Mr. Myers today in the courthouse prior to the proceeding. Is that correct?
Yes, and we discussed how this is going to proceed today.
Great. Okay. I guess we're ready for argument. Ms. Giles.
Your Honor, so his initial appearance, where he did receive release conditions in his case for felony offenses for which he has been charged. After that date, then he went and posted these two videos. These two videos from March 16th and March 17th were both done while he was on release. At the time, he did have the active injunction against harassment, which is an element of the aggravated harassment statute. As the evidence has shown, that injunction was served. It was in favor of the victim. It was served on Mr. Myers while he was in court, and it was still valid as of the date of these offenses. For aggravated harassment, we have to show that the defendant, with intent to harass or knowing that he was harassing another person, and then it's that he communicated or caused a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means in a manner that harassed. And so for that, he caused a communication because he went onto his YouTube channel knowing he has, over 15,000 followers. He went onto that channel and he posted the contact information for the work contact information for our victim, Shannon Walker. And the only reason that he would do that is because he's trying to elicit people to make the contact with her. He could have talked about his case without ever posting her information, but he put it up there clearly for all his followers to see so that they could see in the slapping style sanctions video where he's putting up her work address. And then in the other video, the public, I forgot the name of it, but publicly available public information video. He put that one up and that displayed her email address. It displayed her phone number. And both of those then caused the communication with the other. He knew that this would happen because he was on notice. As you heard from the testimony yesterday, Mr. Myers has acknowledged that he knows his followers reach out to the victim. He knows that this happens. So he's on notice of that. He knew what the nature of the type of the contact they have. And so he's still doing it. So he's still eliciting them to then reach out to the victim. The definition of harassment means conduct directed at a specific person, which would cause a reasonable person to be seriously alarmed, annoyed, harassed, and the conduct, in fact, seriously alarms, annoys, and harasses the person. So we know it's directed at a specific person. This isn't just him talking about his case. He directed it specifically at Shannon Walker by putting up her information. So he's then calling on his followers to reach out to her because this is something he's had the history of doing this, of repeatedly putting up these videos for Shannon Walker and putting up the contact information so then people would reach out to her. And in fact, that is what happened. You heard some of the voicemails, you heard two of the voicemails that were admitted into evidence, and then you admitted into evidence for some of the emails that she was getting that were in response that happened shortly after he posted these two different videos with her contact information. One of them specifically references, it was the gentleman who was coughing throughout, specifically references the content that was contained within that slapping style sanction video. And so it's clear that that communication was in direct response to that video. It references the University of Arizona, which is referencing the injunction that he put up. And while we only played a clip of that, the court does have the full video. And in the full video, he does go through and talks about that there was this thing in the police report that referenced the X, and that he talks in that video about that, and then that voicemail does reference that. So harassment, you have both the objective standard and the subjective standard. So you have the objective standard of what a reasonable person would they be seriously alarmed, annoyed, and harassed by this conduct. And with the emails, the content of these emails is referencing, her being raped, her being shot, things happening in front of her children, these voicemails of going to her home. This is all conduct that would cause a reasonable person to be seriously alarmed, annoyed, and harassed. And then you also heard Detective Brown reference that Shannon Walker is in fact seriously alarmed, annoyed, and harassed because she's afraid for her family, she's afraid for herself, so she has safety concerns. So we have both the objective and that subjective standard. And so these elements have been supported at this hearing under Article 2, Section 22. The standard is proof evident, presumption great. And we have the videos that were produced by Mr. Myers. So we have the evidence showing that he was doing this, the testimony indicating that he knew this is what his followers would do, that this has been going on for a period of time. So this is repeat communications. And then we have the result of what happened when he then caused a communication with another by causing his followers then to reach out to Shannon Walker. So for those reasons, we would ask the court to find that we've met that standard and to hold him without bond.
Thank you, Ms. Stiles. Mr. Pervin.
Thank you, Your Honor. Your Honor, as there appears to be many people watching this proceeding on YouTube, I'm going to explain a little about what this proceeding is not. This hearing is not about whether Lane Myers is guilty or innocent of any crime. This hearing is not about the 14 charges already filed with this courthouse. The rules of evidence are more relaxed for this proceeding. This is not a trial on the evidence. This hearing is only about 2 alleged incidents involving YouTube. Both the United States and Arizona constitutions favor pretrial release. People are presumed innocent. People should not be in jail where it is incredibly hard to defend oneself. Arizona acknowledges this fact under the rules of criminal procedure and requires the least onerous conditions release necessary for the situation. Bail is a right in the state that should not be taken lightly. Before this court can deprive Mr. Myers of his right to bail, his constitutional right to bail, it needs to find that there is proof evident, both that Mr. Myers was in fact on pretrial release and that the alleged conduct was a felony. What is proof evident? Proof evident is more than probable cause. In fact, it is more than a preponderance of evidence. Although the courts have ruled the level of proof does not need to be beyond all reasonable doubt, unlike a jury trial, the courts have made it clear this is nonetheless a high standard of proof. It must be clear to this court that a felony was committed on pretrial release. Let's start on whether this even happened on pretrial release. The detective testified he thinks these videos were made after Mr. Myers was on pretrial release. However, the detective admitted he had no way of knowing for sure when the videos were made. He didn't know the time. He appears to be going off what he thinks YouTube may have labeled it as, but he doesn't know for sure. The state didn't submit any evidence of timestamps proving when these videos were made. Furthermore, the minute entries were not entered until March 17th. There simply was not time to enter anything on March 14th. The hearing ran late. It was heated. Security was here. Mr. Myers was escorted out to the situation because it was so heated and told to come back the following week to meet with pretrial services. Given this situation, how late it ran, as if the court noted, we ran late yesterday too, it had to be continued. Same reasoning. I argue that the proceeding was not official until the 17th, when the minute entry was filed with the courts and Mr. Myers officially knew his release conditions based on that minute entry, given how heated it was and had to be escorted out. However, the biggest argument here is that the conduct stopped. I asked the detective if there were any further videos reported. He said no, or not that he was aware, but it was a no. This means that once Mr. Myers was given his release conditions and on pretrial release, he was aware of them and stopped all conduct of these videos. Mr. Myers was not arrested on these new charges until March 20th, in court, by the way. He's doing his duty to come to court. He's always coming to court, never fails to appear. There were no videos posted on March 18th. There was nothing posted on March 19th. The conduct stopped pursuant to the detective's own testimony. Mr. Myers was summoned to go to court. He knew these charges were coming. He was understandably upset and exercised his First Amendment right to make some YouTube videos expressing his concerns. He was not on pretrial release when he received the summons. The fact that these videos stopped before he was arrested for these charges a few days later, that has to mean something to this court. This shows that the court's order of pretrial release was obeyed once it was official. This court should not deny Mr. Myers' right, his constitutional right to bail, on a timing of incidents so close together when the testimony shows the videos stopped. I am not arguing the state can't charge Mr. Myers for what they believe were contained in these new videos. I am arguing that there is no proof evident these incidents occurred on pretrial release. The conduct stopped. This court should not deprive Mr. Myers from his right to bail when the evidence shows he complied and stopped making videos. Next, I want to discuss whether a felony even occurred. The state argues that 2 clips presented to this court rise to the level of aggravated harassment. However, if the court reviews the state's own exhibits that they submitted to you, the email started March 15th. If the detective believes, but again, he's not sure when exactly, but if he believes that the videos happened later, then why did the emails in response to these videos start on March 15th? Either the videos occurred earlier in time, which means Mr. Myers was not yet on pretrial release, or Ms. Walker's email was already known to the public, in which case Mr. Myers was not responsible for this, what happened after. Or maybe it's both. But no matter which route the court prefers, it's the same result. There simply is no proof evident here. The state cannot meet its burden to deprive Mr. Myers of his highly important constitutional rights for release pending trial so he can defend himself outside of custody. Finally, there is the content of the alleged videos. In the first one, Lane Myers is simply defending himself and explaining a court document. Is the state really arguing that the explanation and posting of a court document listing the University of Arizona Law School's address somehow caused to mail? Nowhere in that video did Mr. Myers tell anyone to contact Ms. Walker. He simply was explaining his legal proceeding and how he feels about it. That's not a crime. Certainly wasn't a felony. Maybe the court made a mistake in not listing the law school's address as confidential. Maybe it should have been. I don't know why the court, left that non-confidential on this injunction. However, if there was no mistake here, then certainly there's no crime in posting the address of a law school. The court should see this was a legal discussion in this video and had nothing to do with contacting Ms. Walker. In fact, the first thing the state mentioned was it requires intent. Clearly, there's no intent in that video to harass anyone. It's just explaining an injunction order, how he feels about it, and how he's defending himself. The second video is admittedly slightly trickier. However, as the court saw, this video was silent. It was labeled public information. Ms. Walker's information was not the only one listed or displayed. The video went through several pages of the University of Arizona's website and showed numerous people and their credentials. If the court reveals the entire video, although we only saw a clip, even more names are listed. Public information. Now, it perhaps would have been more prudent not to post anything at all once the summons was received. That being said, Mr. Myers has a First Amendment right to talk about his case and explain how easy it is to see public information online. If the video were solely focused just on Ms. Walker's contact information with instructions to contact her, that would be one thing. But it was a constantly changing video, as the court saw, flashing various things real quick, showing many people. That's not a felony. Now, lots of people were upset when Mr. Myers was charged. Lots of people watched the live streams as he was arraigned. As has already been established, lots of people must have already had her email. Or if they didn't, these videos were posted earlier and he wasn't on pretrial release. It's one of the two. Lots of people were upset. What we heard yesterday about what others, not Mr. Myers, third parties, I don't know from where, what these third parties, these people are doing, watching these videos, he's commenting, what these emails, it's disgusting. It's despicable. I think it made us all cringe, myself included. That is just one of those awful things I've heard said to someone. It's sad. No one should be doing this to people. However, it was very clearly established, including by the detective's testimony, that Mr. Myers was not initiating these emails or phone calls. Mr. Myers has never posted anything private about Ms. Walker. He would never initiate a contact like that. This isn't coming from him. These people have her email already. How they got it, I don't know. But it wasn't from these two videos. Now, I don't know if whatever Mr. Myers did in those already 14 charged offenses caused these horrible things that's now happening to Ms. Walker. They might have. Sadly, yes. I don't know for sure. Mr. Myers in the process of defending himself in all 14 charges. But whatever he did there, maybe that's what caused that. But that's in the past. That's not why we're here today. The only question today was, did these two new videos really rise to additional felonies? Really committed while on pretrial release? They weren't. These two videos didn't add anything. At best, perhaps Mr. Myers may have violated the injunction and might be guilty, based on that video, of a misdemeanor crime of interference with judicial proceedings. But that is not a felony. It does not deprive Mr. Myers of his constitutional right to release, even if he is guilty potentially of the misdemeanor crime of violating that injunction order. With that being said, for all the reasons already mentioned, I ask that this court grant Mr. Myers release conditions here, because the state simply cannot meet their burden here to deprive Mr. Myers of such an important constitutional right to be outside of custody and defend himself. I'm not arguing the state can't pursue charges. They clearly have. They have some strong evidence for those 14 charges. They do. But Mr. Myers also has the right to bail. The state simply cannot take that away based on this evidence today, simply for these two extra videos that did not rise to additional felonies. Mr. Myers should be able to defend himself for those 14 charges, and if necessary, these last two, which questionably may be additional charges, but not, I really don't think there's enough proof for felonies here, Your Honor. And with that, I ask that you issue some perhaps quite stringent release conditions to ensure this, that everybody's protected here, the victim, but definitely issue release conditions. I think Mr. Myers deserves that. He's entitled to it. The state has not met their burden, Your Honor.
Thank you, Mr. Parvin. Ms. Stiles, last word.
Your Honor, the only thing Ms. Walker did in this case is she happens to be married to a prosecutor. She had no connection, as you heard in the testimony, to Mr. Myers, absent her relationship with her husband, that brought on that Mr. Myers then started this retaliatory smear campaign against Shannon Walker. He turned these people onto her. And so you heard testimony about the backstory, that this had been going on, that he had started posting on her and then causing his followers to be reaching out to her. He then, even though there's an injunction put in place, and the injunction tells him, do not have contact, do not cause contact, do not post her work address. He was put on notice of all of this. He is put on notice that this was happening to her, and yet he continued doing it. He didn't stop. He just kept going. And so then you hear that he's put on release, like he's at the hearing. So this argument that maybe he didn't know because it was a heated hearing, he was at the hearing in person on March 14th. He was present. That's when the court ordered the release conditions. That's when he was notified. He is on release. He had his arraignment. He was informed of these felony charges. So he knew he was facing all these aggravated harassment charges, misdemeanor charges, the felony charges of aggravated harassment, a stalking charge. So he was on notice of all of these things. And as defense counsel noted, there were a lot of people that were very heated and upset about this. But what did he do? He went online again on the 16th and 17th, and he posted her information again, even though he had been on notice that this was causing all this harm to her, that it was causing these people that were following him to do this. And so he went into it. We don't have to show that that was his intent. The other standard is that he knew that he was harassing another person by causing a communication with her. So he is providing the means for those people to contact her by giving the address and the phone number and the email. So maybe some of them had it, but he was definitely making sure more people had it, because there would be no reason for him to be posting that information to those people other than calling on them to then contact her and take that anger that they had and direct it again towards her. Again, because he's retaliating for the fact that he is now facing these charges. You heard the detective testify that he himself, when he went on YouTube to get these videos, that he himself was able to see when these videos were posted. And then the court got the voicemails that then came right after it, showing that this was in response to what he was posting. So he was calling upon these people to do that. And this isn't where we just have to say in this vacuum of just these two charges, the history matters into what showing that his intent or his knowledge of this. And so that's why you heard the detective testify about that history, that he knew what the response was going to be. He did it anyhow. And so it meets that standard of that he meets both the objective and the subjective standard of causing that harassment to Shannon Walker. He caused that communication, knowing he had an injunction, knowing she didn't want to have contact with him, and knowing what his followers were going to do. And he did it anyhow, even with all that knowledge. And sure enough, it did exactly what he was setting out to do. She got that contact. She got those harassing emails. She got the harassing voice messages that scared her for the safety of her and her family, all because she just happens to be married to a prosecutor and had no other connection to this man. And so for those reasons, we're asking that you find the standard that the elements of showing that he was on felony release have been met, and the fact that the elements for the aggravated harassment, which is a felony, we have two different dates. The court only needs to find one, but the aggravated harassment was met, and we're asking you to hold them without bond.
Thank you. All right, folks, I'm going to jump off the bench, take a few minutes so that I have an opportunity to review the documents that were provided. I do intend to rewatch the state's exhibits with respect to the two videos. So give me about 10 minutes. I just want to make sure I'm very clear on what we saw yesterday before I issue my ruling. So stay seated. No one needs to get up. I will be back. Give me, I would say, about 10 minutes, and I will roll from the bench. Thank you.
Use the restroom.
All right, guys, what do you think? What about the closing arguments there? I don't think it went, his defense attorney went quite in depth into what he should have gone into, but he was on point. But they didn't even address whether she's a state actor. And I don't even know, his lawyer doesn't think that matters, I guess. All right, so everybody knows. So on April 15th, is when at 9 o'clock in the morning is when Lane's next hearing is. Okay. I put in Pigs Under Pressure. We all put in to audio and video in it. It was denied. And also, see who else put in for it. At least two of us put in for it. And then I guess, this is a public service put in for it too. And I'm on the same denial letter as him. They denied his because they thought Lane was part of the company. I don't know why they thought that or why Lane said that. He did say that at the last hearing or something. And I don't know why that would even matter, whether he's doing it or a third party. But I put in one too. And as a third party, I put in as a third party, and I was denied today too. I put into it about a week ago, and I was denied because on the bottom under additional information, I also put in there that I was going to be doing a press conference after this in the courthouse after the court was closed, after the case was over. And they put that as the reason that I can't do that. The judge is the one that told me I can't do that. Well, he has no control outside in the courthouse. And outside in the courthouse, as far as I'm concerned, I have to follow 122.1 in the courthouse, which means I just have to have express permission from the person I'm recording. Well, I'll have that because I'll be recording myself, and whoever else was in there that's going to give me permission, or they wouldn't walk in front of the camera. I would do this in the area where there ain't no other people, back in the corner where just the people that walk in front of the camera, you'd be able to see. But they denied my request, and I resubmitted it and took out the part where I'm going to be out in the courthouse, and they instantly denied that again too. And then Pigs Under Pressure put in the same thing, and he was also denied. He was sent the same denial letter with my name on it. So anyway, that's what's going on. And so they're not going to let anybody audio and video record. And they even denied me 122H, that they're going to be broadcasting their audio so no one else can do audio. Well, as you saw at the beginning of this, 122H, you don't need permission. All you have to do is notify. So that judge can't do that. That's Judge Metcalf in Superior Court. And he just doesn't know what he's doing. He doesn't understand 122 or fails to read it. And I spelled it out to them. 122C says they can't deny me without having a hearing. If they're not going to automatically approve it, then they have to have a hearing. They can approve it without a hearing, but they can't deny it without a hearing. It's right on 122H. 122C, I'm sorry. So let me read exactly what it says. 122C. Okay, 122 says, except as provided in paragraph H and I, which means you can do it without permission in H and I of this rule, a person who wishes to use a recording device during a proceeding must submit a written or electronic request to cover the proceedings as follows. And then it talks about recommending for a suspension of a request. The person must submit the request to the judge who will conduct the proceedings or to an office of the court authorized to receive requests under this rule. A person who submits a request to cover a proceeding has standing on the request, but the submission of the request does not confer that the person that statute of a party in this case. Then it goes on to say time limit for suspension of a request. And I did this well in the time limit. A person must submit a request sufficiently in advance of the proceeding to allow the judge to consider in a timely manner. And I put my request in over a week ago. As soon as I heard that date, I put it in. And then A, it says, in the specific proceeding of a trial, a person must submit a request at least 7 calendar days before the trial date. I did. If the proceeding is not a trial, a person must submit a request as soon as possible, no less than 48 hours before the start of the proceeding. C, if the court schedules any proceeding on less than 72 hours notice, a person must file the request as soon as reasonably possible before the proceeding as not to delay or interfere with it. And then 3, okay, that was 2C. Now this is 3. Court action upon receiving the request. The court will notify the parties of the receipt of the request for coverage. The judge will promptly hold a hearing if the judge intends to deny the request or portion of the request, or if the party objects to the request. So either way, they can't deny me unless they have a hearing. Well, he wouldn't let me have a hearing. I put in to have a hearing twice, and he denied me without a hearing, and they can't do that. The judge will promptly hold a hearing if the judge intends to deny the request or a portion of the request or a third party objects. So if the judge denies or a third party objects, they have to have a hearing, and I get to represent my side, and then they got to say their side, and then the judge makes a decision. Well, Judge Metcalf did this without a hearing. He denied audio and video, and he did it against the Rule 122C. So if he wants to deny me, he has to do it in a hearing. He can't do it before the hearing. He can allow me to audio and record, and I put in requests for my own hearing coming up and El Charo's hearing in Justice Court. That judge granted it. So anyway, that judge granted it and says that I can audio and video record, and I did my own hearing, as you guys know, about 2 weeks ago. And that's the same Judge Foreman. Now, he's not a good judge in a couple ways, but he does let you record it. So, kudos for that. At least he has some transparency. He made some bad decisions before, because he told me I can't do 122H. And he didn't understand 122 at that time. But now he does. I mean, he's given me permission under 122C. 122C allows me to audio and video. 122H is only audio, but you only have to notify him in advance. So that's real important here. Hardly any of the judges know this, they don't go by it. The city court doesn't, and the Justice Court and Superior Court here where we're watching. None of them fully understand it. Some of the judges do, but not all of them. You can go hit and miss. We did a test of 3 of them about 3 weeks ago. And Cornejo, she passed with flying colors. The next judge, I can't remember her name. She was another female judge. She kind of passed. She called security up there on us. Judge Cornejo, when the staff told her that I'm going to be audio recording, because when I went in there to tell him, she wasn't on the bench yet. But then I went outside, because you can't do it when the judge is off the bench. You can't record in there. So as soon as the judge came back on the bench, I walked back in, and then I noticed it was Judge Cornejo, which I knew she was going to pass. She understands the Constitution. I've been in her courtroom in the past, and she's always let me record. So she's never denied it ever since I've been trying, going to Justice Court, which is about 6 or 7 years. So anyway, So the second judge, and when the staff told her that I was audio recording, she was saying, sure, he can do that. And then the second judge called security on us, but they didn't do anything. They let us audio broadcast. And then the third judge, Pigs Under Pressure, went into there first. And as I was walking down to the third one, they was throwing him out. So, and I put a video of that. That judge did not understand at all. And he was a judge that does, how do you, when you kick someone out, the landlord tenant problems, he was doing just that. And that was the third time we went into his courtroom, and he denied 122H and threw us out. He did that 3 times. So he's a big failure. So we got to go back and re-educate that guy, and all the judges in Superior Court and Justice Court, as well as City Court. City Court hasn't denied me a 122H since Cranshaw did. Cranshaw told me that no, he was going to find me in contempt of court. And then I tried to read him the rule, and he says, no, I'll go read it myself and rule next time. And the next time I came in, my lawyer told me not to record. Don't do it. And I said, I am going to do it. And then when I went up to Judge Cranshaw, I was just audio recording. Judge Cranshaw said in a written notice that I could audio record. So this is a lot of talking. Yep, Aaron Queen. What do you want to see? Some pineapples instead? But yeah, they said 10 minutes, so now you have to listen to me talk for 10 minutes. Or you find another channel. I think John Felix was covering it, and so was This Is a Public Service. So yeah, pineapple. But yeah, I am reading the text now. Usually when I'm live streaming, I don't even read the chat, as most people know. Every now and then, I usually when I'm live, it's because they've already called the cops on me. Almost every time is when the cops are there, or if I'm in any of the courts, they always call the cops on me. So anyway, yeah. But they're going to give it, they're going to give in 10 minutes, she said, so we'll wait and see what happens. Until then, Aaron Queen, you have to listen to me talk. What do you think of that? But yeah, we did put in a request. So here's what's coming up. My hearing, they put off for 6 months. So my next one's in September. El Charro's is April 10th, before Lane Myers. And I'm going to be live, not live streaming it. I'm going to be recording it. I'll probably be live broadcasting it, the audio, but, or I'll have Tucson Toe Tag, or someone else will probably be doing that, because I'm going to be audio and video recording it. And then I can post that as soon as I get it uploaded. So it'll be better than just the audio, because you'll get to see. And in city court, they always make me put it on the judge. In justice court, every time I did audio and video recording, which is quite a few times, probably over 20, every time I do it, they don't tell me I have to keep it on the judge. So I can put it on the prosecutor. I can even have a 360 cam. The last time I did it in justice court under 122C, audio and video, maybe last time or 2 times ago, it was no problem at all. And I could show the people, the witnesses too. I could have a 360 cam, but I had 2 different cameras, a GoPro and then the other one, and I was able to turn it back to see who the witnesses were. And that's when that was the time that I called a bunch of state actors, 3 of the top guys from the city court. Alan Merritt, I called as a witness, and Mr. Cornman, the head of the security that always fucks with us, tucks with us, I should say. And anyway, and I had a couple of security guards, and then a few police officers. And soon as I was to do that, the guy Christopher Avery was the attorney in that case, and he didn't show up. And this was the 5th day of trial, and all it was is to finish. And since he didn't want me putting his boss on there, he just dropped the case. And all this was an injunction against workplace harassment for Tucson City Court to keep me away from there for another year. They did it for 1 year, and I appealed it, and I won. They did 3 of them on me. I won on appeal 100%. And then the last one, I won before the appeal was even over, before I won it with the judge before it got put into place. And then the other one, I won on appeal, just the part that I don't need permission, because they had on my injunction that I couldn't go into city court and record without permission from the presiding judge. And they ruled that no, I don't have to. And they ruled that I don't have to get permission when I'm audio recording in a courtroom, because they told them in my injunction against workplace harassment, I couldn't record in the courtroom at all, And then they ruled against them and said, no, I just have to follow 122H, which means I can audio record. So I was able to audio record when I was under the injunction. So, and then that's when they put out that 50-4, which says, and then all the other courts followed it, which the administrative order, which says that you can't even record outside through the window, all that stuff. So I had more rights when I was under the injunction, because they put in there, all I had to do is follow 122 and 122.1. 122 covers the courthouse, the courtroom, and 122.1 covers the courthouse. So anyway, this is 120. This is 122 right here, guys. I don't know if there's enough even light to see it, but I always have this with me when I'm going into these criminal courts, because but they don't care. Dick Tracy, and I also have Judge Gordon's ruling. Judge Gordon's ruling is the ruling that said I didn't need permission, and that's one of the main things that I keep trying to read to Dick Tracy, and he won't hear it. Their judge in Superior Court already ruled on this, and it's right here. The light's so horrible, huh? I have to turn on my backlight. Anyway, what this says. Let me turn on this backlight here and see. Anyway, argument number 2 right here. That's argument number 2. I'm going to read it to you. Brown argues that the Pima County Justice Court misread Rules 122 and 122.1. To the extent that Pima County Justice Court reads 122 and 122.1 to require Brown to get judicial permission before recording outside the courtroom in the courthouse, and to always get judicial permission before using a personal audio recorder inside the courtroom. The court agrees with Brown. Okay, and they go further on to say, the injunction incorrectly states that Rule 122 requires Brown to secure judicial permission to film outside the courtroom in the courthouse, and potentially overlooks 122H, limited exception for the use of a personal audio recorder in the courtroom. And that's what I've been telling them all along, that all I have to do is give them notice. I don't need their permission. So the court, therefore, will remand the case back to Pima County Justice Court so the injunction can be modified to reflect a proper or more clear reading of these rules as set forth. So right away, the 122H, you don't need anyone's permission. You don't need the judge's permission. you don't need anyone's permission to audio record. And then out in the courthouse, you only need to get express consent from the person you're recording. So I can be in the record house and record anybody that wants to be interviewed, and wants to go on camera. And I can record the courthouse, all the artwork, all that stuff I can record. I just can't record anyone that don't give me their express permission. Now, as it says individual, under the definitions of a person. So individual includes a person. So under the definitions in this rule, here's 6 of them. The sixth one is, the fifth one. The fifth one right here, right by my thumb right there, is the definition of a person. Okay, so that means I have to get express permission from any person. And here's the definition of a person. A person includes an individual and any organization except the court. Except the court, guys. So anyone that works for the court, I can record them. And the reason they put that in there is because the reason they put except the court is because that we have the right to film our public officials in the course of their duty. Otherwise, why would they put them 3 words in there? And like I said before, it ain't like they had 3 extra words. They just had to put them there. They put them for a reason. And the reason is we have the right to film our public officials. Now, the other thing that we got going that I don't have out right here is a lawsuit. 3 or 4 of us have a lawsuit on this already. Slinky, Roy Rawdog, El Charo, and me, for all 3 courts, for them to follow 122 and 122.1. So we're in the federal court right now in the Ninth Circuit on this issue. And that's why they put back my court hearing for 6 months, is to allow the Ninth Circuit to have time to hear it. It's been in the Ninth Circuit a year and 3 months now. So we're still waiting. We're still waiting on that answer. And that answer is going to answer all these questions because we're right on point. There ain't no excessive force in this lawsuit like all the other ones. There ain't none of that. The only thing in this lawsuit is the 3 courts following 122 and 122.1. And remember, we think even that is too overbearing. We think we have the total right to film in the court. If anything should be transparent, it should be the courts. They should live stream, as far as I'm concerned, every court hearing, audio and video, every single one should be live streamed. And let me go back and read some of the comments here. Let's see. The man who hides in a shed. That ain't me. I don't have a shed, guys. Oh, I do have a shed. I keep all my stuff in it. Yeah. Oh, they're talking about D. I see. You got me hiding on 30 acres of freedom. And I agree with D on that. I lived out in the Chiricahua Mountains and on 40 acres. And he's right about that. You can put yourself right in the middle and you could have a big, if your thing's fenced and you put no trespassing signs around, you have a big buffer zone. And I would rather live like Direct D also. I have to stay in Tucson because of my work, or I would be out just like him. And I had property out there, in northern Arizona, and I like it out there. They have nice pines, Can you ask D where he hid the charger? I think he has it parked right on his property. All them pictures I saw Lane Myers posting, I remember that charger on there as a black hood, if I remember right. He put a phone up his butt and is right and chatters. Whatever that means. Hello, Brent. Hi, Tuck and Chatties. So, Yeah, yeah, I agree too. Every court should be, they should be live broadcasting it. If not, they should give everybody that wants to record permission, and they have to give you permission to audio record it as you hear, but they still don't. They don't always do that. These judges think they're above the law. They think their administrative order is above a Supreme Court rule, And in Arizona, the Supreme Court rule is over all the courts in Arizona, except the federal courts go by their own stuff. But all the lower courts, the city courts, all the municipal courts, city justice, and superior, all of them have to go under 122 and 122.1. But even though they don't, and even then, it's a rule. It's not a law. There ain't no punishment as far as being arrested for it. They can't arrest you for violating one of their stupid rules, but we even go in there and don't violate 122.1, but you cannot help but violate their administrative order, because their administrative order is just crazy. It just says you can't do anything without permission. And I won that under Judge Gordon's ruling. I don't need no stinking permission. I don't need permission, okay? And remember again, that was when I was under injunction of harassment, just like Lane Myers is now. My injunction of harassment covered the court and Christopher Hell. He was the one that didn't want me recording in there, and he was the administrator. And he got laid off within the first 6 months of this fight. So they suspended, they put him and brought a new guy in charge, and he was obsessed with us. I was in court with him all the time. He was doing things like Dick Tracy. He was always watching every one of my live streams and critical of it. He came in the chat, and I let him do it. I didn't block Christopher Hell. I don't block anybody for saying, if they want to say bad things about me. I have pretty thick skin. I really don't care what they say about me, but Christopher Hell was obsessed with us. On that last hearing, when they didn't show up, the last case, this was the 5th day of hearing, but on that last case, he had his computer hooked up to the big screen TV, and he had hundreds of my videos. He was flipping through it, and I was laughing because they was putting that up on the big stream. If you want to go back about 4 or 5 years on my live streams, I put that up. Not live stream, but that was that I recorded it and posted it later. But you see, 2 days before that hearing, 5 years ago or whatever, 2 days before the hearing, when they put my stuff, we posted a new version of that, which had Christopher Hell. El Charro made it up with him dancing in a pink tutu. We put that in front of it. That's the one they brought to show the judge. And then they objected to it. And we laughed because we submitted the correct one, the one without him, the one that wasn't edited at all. We put that one in there. And he posted that, Christopher Hell did, as he was showing all the videos that he had on me. He was obsessed with my channel, just like these guys are with Lane Myers' channel. When he does a 9-hour live stream, they're watching every minute of it. And that's what I love about it, because that's why I think he should be monetized, so he makes them watch ads, and that's one of the problems, Let me read some of these chats here. Tuck, you still have a Tucson shirt for sale? Brandon Mitchell, I never sold one, but yes, I have. I never sold one. I give them away. Anyone that gets arrested by Tucson police, I give one, I already gave Lane 5 of them. He keeps getting arrested. Now I owe him another one, But anyway, I never sold one. I give them away. If you're ever in town, look me up. Anyone can go to my email is easy to remember. TucsonPoliceSuck@gmail.com. So you can text me if you're ever in Tucson. I hand them away. Now I don't do any shipping, because I just give them to people here in Tucson, and I probably gave away about 150 of them now. So far, I bought 2 sets of 100. I have them made in my I have them made by my friend that I've just been doing t-shirts since he was 14, and he's like 2 years older than me, and I'm 63. So he's already retired, but he still does t-shirts. He used to work for big companies and been doing that his whole life. Now he's been working for himself for about 15 years. He does all my t-shirts. I went down to do them locally. Most of the places won't do them. They won't do anything against Tucson police, because they're scared. But I have people that ain't scared, that don't give a shit, and they don't even know who prints my shirts. But they won't be able to retaliate against him because he's already retired and works for himself. So ship to Australia, please. Yeah. In the future, I might do something with that, but right now I don't. I just give them away. And anyone from Australia wants a shirt, Tucson, Arizona, we have an international airport. Fly on in here. Email me at Tucson Police Suck. We'll go out and do cop watching. Anyone that wants a t-shirt, just come down and let's go cop watching. I give them to people that's been arrested by Tucson police, but I also give them to, I go out to the homeless camps and stuff, and I give them away to homeless. And when I'm wearing one and people come up and ask me about it, I always have them with me in my in the car I go cop watching with. Yes, you can, Aaron Queen. We'll go cop watching together. You can come on down. I'll see if I can get James Freeman to go cop watching with you. Can Direct D join us? Yes. I invited Direct D to come down and cop watch and Bow. I told them both I'll go cop watching with both of them. Direct D and Bow. As if they don't fight. But yeah, Bow agreed to it, but Direct D, I never really pressed it with him. Bow said, yeah, he'll go cop watching. He won't come to Tucson because he's got warrants. But I said, how about Mesa? But then again, Mesa's not good either because then Direct D has problems there. But hell, how about we go to Leon Valley? Direct D, you in here, the chat? Let's go cop watching in Leon Valley. I ain't been cop watching there for a while. I ain't went into their police station since I was tased. And now that we won that lawsuit, I can go back now. I was kept out of there for like 3 years. I couldn't even step on their property. Bow will do anything for free stuff. Yeah, Bow's got some Tucson Police Suck shirts. I did cop watching with Freeman and Johnny 5-0 and Direct D and others in Glendale. I did cop watch in Leon Valley with Jack Miller too. Yep. And Jack Miller was the only one in the lawsuit. There was 12 of us that won that lawsuit of $500,000. Jack Miller was the only one in that lawsuit that didn't get his camera taken. On that day, he didn't get his freedom taken. He went back to his car and put away his gun because he was doing the Second Amendment stuff. And then he was walking back, and that's when they came out and arrested everybody. When they said, hey, we're going to have a press conference in 30 minutes, he went and put all that away. When he was walking back, he saw them all get arrested, and then he turned around, got in his car, and left. He got $5,000 just because they denied his right to record because they scared him by arresting everybody else. All the other so-called channels or press. There was even one group press in there was the local Hispanic channel in San Antonio. They even left early. None of them got detained, but Jack Miller got $5,000 just because they scared him away from coming and recording, and they arrested everybody else. I think he's the only one that got away. They arrested News Now, Houston, Bow, Freeman. There's too many to name. They arrested a lot more than just the 12 that signed up for the lawsuit. And originally that lawsuit was Radner. He's the one that did the lawsuit at first, And then he dropped out of it about 2 years into it. And then Brandon Gramble took over. So I don't know if he got any of that money when they settled, because he did do that TRO, and he was in San Antonio for 5 or 6 hours, just drilling Savaggio and them guys, in the beginning on the TRO. Hey, Joko, Kansas. Anyway, Johnson County, Kansas. I know where he's at. I mean, I'm from Kansas too, guys. Most people know. In Kansas, you can tell where someone's from by their license plate. They put the county. If you're Riley County, if you're in Johnson County, they put 2 letters. Out in Arizona, if they run the plate, if they look at the plate, you can't tell where they're from. In Kansas, they break it down for each county. I was from Riley County. I'm from Manhattan, Kansas. Most people know, but I ain't lived there since 1983. I left there in 83, and I went back a lot, but I never went back to live. I think the most I ever went back there was a month or 2. Pat, I had some slightly different issues with Google and now use them for social media accounts. Encryption, only my private business. Yep. That's the way to do it. Privacy is important when you're online. You ain't posting people's channels. Welcome in, Dave. Trying to make everybody a moderator, except for you, Aaron Queen. And remember, all my moderators, don't delete or block anybody. I didn't even know how to even look at who's blocked. I did that the other day, about 5 days ago. I went on there and I unblocked everybody that was blocked. And I realized something I didn't ever know. James Freeman's never came into my chat, and I found out why. Somebody blocked James Freeman. One of my moderators blocked him. And the only way that I'll moderate someone is when they come into my live chat. Otherwise, I don't even know how to moderate them. So anyway, that's why I make everybody a moderator, so you can't be blocked. But if somebody comes on and says something, any moderator can block them before I see it. And when I'm live, usually I'm not reading my chat. So if that keeps happening like that, I just got to check it every week to make sure no one's blocked. If that keeps happening a lot, then I'll do it the other way. I'll remove all the moderators. I believe there's 2 ways to do it. Moderate everybody or moderate nobody. Yes, Aaron don't get respect. And the only reason he did, he's probably the one that blocked Freeman. I'm sure. Right, Aaron? Did you block Freeman? Because he was a moderator for quite a while. I just took him off about 3 weeks ago when he blocked somebody when I was watching, because I usually don't go back and read the live chat. Every now and then, Grande Johnson 3. Okay, is that you? You're Grande Johnson the first, so you can't be 3. But you're a moderator now, Grande Johnson 3. I haven't blocked anyone, faggot. Someone says DirectD blocks. Yeah, DirectD's like me. I don't think he times people out sometimes, but I don't think he does block anybody. Yeah, I'm for freedom of speech. I don't care what you say about me. You can talk shit about me all you want. You can talk shit about the people I like. You can talk shit. DirectD, you can talk shit about anyone in the chat, and anyone can talk shit about DirectD. The same way you can do on his chat. You can go talk shit about him on his own chat if you want. I try to, as most people know, I try to stay out of the drama. So that's why I mod everybody, is so they can't be blocked. But I try to stay out of the drama as far as all the You know, I try to keep my focus on the police and the government officials that are ruining our lives. I try to stick on that. Now, as you guys know, I do things on the American Legion, and I'm going to be doing a lot in the future because they're putting injunction of harassment on me. They call the police on me all the time. So every time they call the police on me, I go live there. Otherwise, I don't really give a shit, you know. And as most people don't know, I don't even care about going to that American Legion Post 7. The only reason I go there is because they told me I can't. You know, that place is a 100-year-old building. It smells like mold. I don't like going in there. You know, I would like going in there with a gas mask. I don't. My wife used to work in that kitchen 5 years ago and go in there and cook for the veterans. You know, and that is a nasty ass kitchen. I won't eat there. But that whole place is just nasty. You know, the only reason I'm still a member is because they told me I can't be a member. They sent me a letter telling me that I need to find another post and I shouldn't be a member there. Well, that's the only reason I'm there. I don't like that place. I don't drink. I don't drink at all. So I never go in there and have a beer. That's all they're about is alcohol, you know, and they do that Queen of Hearts, which is gambling. They get people to come in there and buy food and alcohol. And then, and if the pot is up to $4,000, or last time I think it was close to $6,000, the person that wins it gets $6,000. And then the club, the American Legion Post 7, the commander, the asshole commander, gets $6,000 to go buy booze for himself and his friends, you know? So that's all that Queen of Hearts is about, is supporting them. That's why they don't want me, Dave, my wife, or Dave's wife in there, because we expose them. And the only way to kick out members is by the members putting it up to a vote and getting rid of you. The commander has no say other than one vote in that. He can't do it himself, which he does though, because I went there 2 weeks ago, and they gave me the injunction, but they didn't serve me. They don't know how to serve yet. And the last time I was arrested there, that's coming up on 2 years right now, and I still ain't went to trial on that. So basically, they're going to end up dropping all these charges. I got eight pending charges that they keep punting back. So the American Legion is trying to put another injunction on me, but they ain't served me yet. So as soon as I get served, then I got 10 days to go down. No, they got 10 days after I go ask for a hearing. They got 10 days to give me a hearing, 10 business days. So as soon as they do serve me, you know, I'm going to go down there and request a hearing. As of right now, I can still go to the American Legion, you know, and they gave me the paper that says I can't, but they didn't serve me. And last time I got arrested, I wasn't served until the cops came. And I told them I'll wait for the Tucson police, because the Tucson police can serve me. If they have a blank copy of it, they can serve me and they can turn it in. Otherwise, a service has to serve me, the person that has the service. Malrata owns the chat. Welcome in, King. You're now a moderator. What was you? King Bow Bow. Oh, King Bow Bow. So anyway, Catilla the Hun Freedom Fighter. Yeah, Northwest, I ain't heard from her in a while. Have you? She ain't posted nothing in about, 4.5 years, you know. And I did talk to her about maybe 2 or 3 years ago, after she already quit for a while. But it's the last time I talked to her. I don't know how she's doing. I know she's not doing anything with her channel. Noli D, she won't even take my calls anymore. I don't know why. Yeah. So, yep, I don't either. I ain't talked to her, like I said, probably 3 years. I think she had her channel gone 5 years ago or so. I have to go back and see when the last post was. But she was out here for a while, as most of you know. I'm a jackpot. I need a wrench, mofo. Yeah, I can't remember. I'm a jackpot. You was blocked. You was blocked on my channel when I went in there to unblock everybody. You was one of the ones that were blocked. James Freeman, I think there was about 15 people blocked on my channel, and I unblocked everybody. And I remember I did. I can't remember why I took your wrench away, because I know you used to have a wrench, and I think it was the same reason as Aaron Queen, that you was timing people out and blocking people. You might have been the guy that blocked James Freeman before I blocked you. I don't know. But anyone that blocks anyone on my channel as a moderator, I'll unmod you. Video judge is watching is no longer. Yes, way longer. That was the longest 10 minutes I've ever seen. But anyway, she ain't came back on him. You better block me again. Well, I don't think I need to block you. You can say whatever you want. You just can't block other people. I don't care what you say. I am a jackpot. You can say any obnoxious thing you want. If you get blocked or your thing hidden, that's because of YouTube, not me. You know, the only thing that I'll probably block someone if they post, personal addresses and they do that kind of thing, but otherwise, you guys got freedom of speech. Praying for common sense from judge. Yeah. Yeah. Judges usually don't have common sense. Come on. Why should I block you again? I'm a jackpot. Say something. Say something bad enough to make me block you. I don't think you can. You can post your own address, First Amendment is powerful. Not in court, it ain't. So, DirectD was timing me out for what? Crying about being blocked is a way more pathetic than whoever did the blocking. I already blocked him. Grande Johnson 3. Hey, Blue Flyer, message retracted. What happened? See, I didn't undo her message. She retracted it herself. Blue Flyer. Three phones, by the way. Brandon Mitchell retracted himself. Yep. Freedom of speech, Blue Flyer and Brandon Mitchell. You can even say something you might regret. Oh no. Quit retracting your messages. Okay, Toe Tag just texted me and said, here we go. So they're going to be going back on now. He's in the courtroom right now. I got people in the courtroom right now, guys. I'm just not there myself. Yay, a wrench for me. Thank Bud. Yeah. You get a wrench. Don't block nobody. The only ones you can block is people that ain't got a wrench. So that'd be, I think I am a jackpot and Aaron Queen are the only two in here, but don't even block them. Let them talk, guys. I'm going to start checking my blocked callers every once a week or so. Yep, he's right. Here they go.
All right, and we are back on the record. I appreciate everyone's patience. I want to make sure that everyone knows what's been going on for the last I think closer to 40 minutes now. When the court got back in chambers, I wasn't able to view the actual CDs without a laptop, and one was not available for the court. So I did ask Ms. Stiles and Mr. Parvin to come back to chambers along with the iPad that the state used so that the court could view the redacted portions, or the portions that were played in court. Once back there, counsel did ask the court to review states 12 and 14, which the court did. So I had a chance to view most of all of those videos. I will say that for states 12, that was the one from March 16th of 2025, slapping style sanctions. That one we did skip through. It was almost an hour long. And the portions that the court viewed with counsel in chambers were the portions that contained documents. There were several portions where Mr. Myers actually was depicted, I think, wearing a t-shirt and a hat, but the court did not view any portions of the video that had just Mr. Myers on it. So unless there was a document displayed on the screen, the parties did fast forward through that. So I want to make it very clear what this court has had the opportunity to review with respect to this case. So I did review states 12 in its entirety. And that one was about 16 minutes in length.
I think you said states 12. Sorry. Okay.
It should be states 12. I had the full clip says states 12 and states 14.
I just want to be clear, so the publicly available public information is the one that you viewed in its entirety.
Yes, sorry, and that is, you're right,
So that was-
Exhibit 14.
Yes.
Yep, Exhibit 14 is the one from March 17th of 2025, publicly available public information. That is the one that was 16 minutes. That's the one that the court viewed in its entirety. There were no conversations between the counsel and court that had anything to do with this case other than literally looking at the videos and reviewing the information and the content that the court wanted to view before making its ruling on this case. Ms. Stiles, anything you want to add to the record that the court made?
No, Your Honor.
Mr. Parvin?
No, Your Honor.
Right. So the purpose of this hearing, and I think Mr. Parvin said it, this is not about whether or not Mr. Myers is guilty or not guilty of the charges that the state may be going forward with respect to this case. What the court is being asked to decide is whether or not Mr. Myers should be held without bond at this time. Arizona Criminal Rule 7.2 is very clear that defendants charged with an offense not eligible for bail under 7.2 V1, someone is not eligible for bail based on a commission of a specified felony or any felony while on pretrial release. A defendant must not be released if the court finds that proof evident, presumption great that the defendant committed under B, any felony offense while the defendant was on pretrial release for a separate felony charge. That's what the court is having to decide today. In reviewing the evidence presented in this case, the evidence presented in Exhibit 6 through 10 do establish that Mr. Myers was on release on another felony matter when the offenses in this case were committed. What that leaves is whether or not there is proof evident, presumption great that the charges the state is going forward with today have been established. In reviewing the two videos, the first one, Exhibit 12, that's the one that occurred on March 16th of 2025, entitled Slapping Style Sanctions. The court will note that in reviewing that information, there was a portion of that video where Mr. Myers specifically talks about his X or an X and emphasizing the fact that there was an X. And as the state's evidence established during Detective Brown's testimony, there is a police report also shown in this particular video that makes reference to Mr. Myers as being an ex. I don't think that that's actually the case. That was evidence, but that was the information that was displayed during this video on March 16th of 2025. That information is important to the court because not only does a caller later in that video actually call in and mention the fact that this appears to be retaliation for an ex retaliating for information. I think that specifically ties back to the fact that the viewers are responding to the information that was posted on March 16th of 2025 in the subsequent emails and phone calls that are made to Ms. Walker in this case. So I do think that the context of the information that is being displayed certainly ties back to the information that was presented with respect to this video. In that video, I will say there was a brief section that I did not review at all, from I think 117 in the video to 137 was something we skipped through in its entirety. So I don't know even the content that was on that particular part of the video. So I want to make sure that I have that in there as well, so it's clear what the court reviewed. In reviewing the information for the March 17th, 2025 publicly available public information that was 16 minutes, I will note that while there were a number of people that were displayed during that particular video, the initial portion of the video did display Ms. Walker's phone and email, as well as a photograph of her on the University of Arizona website. As the scrolling goes down through many of the pictures of other people at the U of A Law School, there is a significant pause when Ms. Walker's photograph and information comes up before he continues to scroll down through other people that were employed by the law school. There are many times during the 16 minutes where he stops and focuses specifically on Samantha Walker, her achievements, Shannon Walker, I'm sorry, the fact that she was a key contact at the law school. I will note that there was a portion where there was a focus on, very briefly, Samantha Walker, which is a different person that was also stopped on again very briefly, but it was very clear during this 16 minutes that he continued to focus on Shannon Walker. There was, in fact, a portion as he was scrolling through where there was a photo of Miss Walker with her husband and her children, where she is shown as a member of the board of directors, and again, very much focused on her throughout that 16 minutes from the March 17th, 2025 video. Mr. Myers has the YouTube channel where a number of people follow. Based on the entire context of the communication in this case, the information provided to the court, I do find proof evident and presumption great that Mr. Myers did commit these offenses. That's only for the purposes of obviously this hearing as it pertains to the aggravated harassment involving Miss Walker on these two videos, so those two counts. And again, looking at ARS 13-2921, harassment, as the state pointed out, a person commits harassment if the person knowingly commits any one of the following acts in a manner that causes, under A1.
It's obvious where this is going.
This is the part, causes the communication with another person by verbal, electronic, and other means. It is the electronic means in this particular situation. And under E, it defines what harass means: conduct that is directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed, and the conduct, in fact, seriously alarms, annoys, humiliates, or mentally distresses the person. There is no doubt, and I think even defense conceded, that the contacts with Ms. Walker in this case are truly offensive and would certainly cause a reasonable person to be annoyed, alarmed, and distressed, mentally distressed. The aggravated harassment statute under 1329-2101 requires that a person commits aggravated harassment as provided in the underlying statute that I just related, and at the time of the offense, any of the following applies. Under A1B, an injunction against harassment pursuant to 12-1809 was issued in this case and was enforceable. For those reasons, the court does find that Mr. Myers is going to be held without bond today. Anything else that we need to do?
No surprise there now.
State's perspective.
Soon as he starts speaking.
Mr. Parvin?
I was just saying, if the court's finding proof evident, can we go straight to arraignment so we can start the 150-day timing? I'm wondering if instead of waiting 10 more days, I understand there's an indictment coming already. I'm saying if the court's found proof evident, that's more than probable cause they're getting. If he just wants to have a speedy trial rights and start the 150 as soon as possible.
Ms. Stiles?
Your Honor, the charges are still set to go to the grand jury. So that process hasn't happened yet. So we don't have the charges to be able to do an arraignment today. If they're wanting to waive a probable cause determination, there are forms that we can prepare to do that. So that's up to. Hey, mama said the way you move. Counts that go through as well, but I can present those to the defense if he wants to waive the probable cause determination. We can do so. If not, it will be proceeding to the grand jury.
I think the important thing, well, I think it's 10 days at March 31st, still some time there for that to be done. But Mr. Myers does want to invoke his speedy trial rights and wants the 150 to start as soon as possible.
Understood. And I think for purposes, again, of this hearing, the court only has to consider one charge. I think the state does have the ability to go forward on other charges. And it does sound like these may not be the only two charges that the state does intend to proceed on. So I'm sure Mr. Myers and Mr. Parvin, you obviously will continue to assert his rights going forward. Anything else that we need to do today? All right.
No, Your Honor.
Thank you all.
Well, that's that. He's fucked. Yep. They go by feelings here in Arizona. That sucks. But no more 9-hour live streams. And here's the biggest problem with this is he was doing long 9-hour live streams. He was making all these government officials watch him. They would watch the whole thing just to get dirt on him, you know, over and over, hundreds of hours over the past, 6 or 7 months that they've been fucking with him, So they save a lot of time by making him not do live streams unless he can still do them through that one chat with this is a public service. I think he's still been going on there and talking, so he can violate his, then they'll probably take that right away. But that's probably what's going to happen. Yep, toe tag just put no bond. Yep, I already know. I heard toe tag. So this is just bond. Yeah. But the main problem with this bond is because now he won't be able to represent himself, and that may be a problem, may not, it may actually help him because, if you represent yourself, there's still, there's a good chance that you're going to fumble. I never seen him go to trial yet. He always, that's right. Broadcast live on a jail is another charge. Yeah. So, yeah, if he's going on channels and just talking while they're doing stuff, so hopefully that won't get the guy in trouble that's actually doing it. I think this is a public service, or Arizona has its share of eyes from the DOJ on them now, even more than before. Yeah, I hope so. I know. Let me see if you guys can hear this. All right. Did you guys hear that? Oh. Okay. Hey, so did you guys hear what he was saying? I don't know if you could hear or not. I answered him on the same phone that I'm using both of my phones now. As you guys probably know, I'm broadcasting that to my TV through my phone because they sent me a link. They sent me the link, but they denied my request to audio and video. And I can still go in there and audio broadcast, but the audio is not as good as the court system at the Superior Court. The city court, mine's better. They suck, but the Superior Court, you can hear it better than if I'm standing behind the prosecutor, and they make us go towards the back sometimes. So, yeah. So you heard nothing. So good. Yeah. So then when I switched over, anyway, what he said is he's outside of the courtroom right now, and there's 10 cops around him. So I told him to walk down the hallway and see if they followed him, but they was just standing there by him, but they didn't follow him. So anyway, I told him about 6 of them were Tucson police, and I told him to go ahead and go outside and then call me, get safe, because when there's that many cops in there, they hate cameras, man. They hate cell phones. They hate cameras. So anyway, let me go ahead and no need to have it on the TV anymore. So I'm going to stop broadcasting it. Oops. Sorry, guys. Turn you sideways. You guys get dizzy? So, hey, MCW Joker. Kind of like vampires and mirrors. Yep. Welcome in, MCW Joker. Let me go ahead and just see here. I'm going to go ahead and cancel this thing. Let me see here. Got to figure out how to cancel this thing. The screen. Let me see here. Let's see if that did it. Nope. Still there. Trying to cancel this. Close player. There it goes. Alrighty. All right, guys. Sorry. I'm using my other phone. All right. Let me see what's in the chat now. I can read the chat. Quick, somebody block Freeman. Freeman, are you in here? Oh, shit. Yep. Now you can't block him. Now you can't block Freeman. If he says something else, he's blue. Too late, guys. That's what happened already. I guess if it wasn't Aaron Queen or I Am a Jackpot, I don't know who blocked Freeman. Sorry, Freeman. I know I didn't block you, and I ain't ever seen you in my chats for years. So you've probably been blocked a long time. I'm pretty stupid about YouTube. I'm trying to educate myself, Freeman. I think I actually, and I did this before, I accidentally made somebody a managing moderator. And they could probably even block me, I remember about 6 years ago when I was starting my YouTube channel, Freeman and Bow was here, and they made Furry Potato a moderator. And then she came in and blocked everybody. Oops. I think I was buffering there, huh? I was walking away from my there he is. Freeman's here. You're not blocked anymore. I don't know how many years you were blocked. I just think you didn't. I thought you just didn't like my channel, Freeman. John, oh yes. John, you're now a moderator. Yeah, so I found out I made a couple people managing a moderator by accident when I'm out in the field when I'm doing cop watching. Freeman the puss has me blocked. He can't see my chat. Now, if you ain't blocked, I am a jackpot. You just ain't blue. You just can't block nobody else. Yeah, don't, the moderators don't block anybody or don't time anybody else out. Freeman's a lurker. Freeman has a few troll accounts, so he could have just went to one of them. But he never told me he was blocked, so he probably didn't know. He probably never went to my channel. All right. I got to show the pineapple for Aaron Queen. This is the same pineapple plant with no pineapple now. But the baby ones there, like I showed last time, all these baby ones are from this mother plant. See, here's one here, look. Pineapple plant, there's the roots. That ain't a fake. Aaron Queen says that's a plastic one. And I had a plastic pineapple stuck to the top of this thing. But all these babies here are from that mother. I think I got my... All right, guys. Oh, sorry about that. That was Tucson tag. So he was starting to talk to me about what was happening in there so you guys can hear the inside story. I told him to call me on my backup phone because when I go over to him, you guys can't hear. So, message retracted. Tag. Hey, Tag. Toe Tag's going to be calling me in on my backup phone. Matter of fact, I think... There he is. Here he is. All righty, now you're live.
All right, man.
Okay, so anyway, what happened? So when you walked in there today, when you came in there, they asked if anybody was with Lane Myers.
Yeah, associated with Lane Myers. It was me and Lane's lawyer. We're only ones in the hallway. And they came up and asked if anybody that's associated with Lane Myers show up yet. So they were all looking for everybody to come.
Yeah.
But they did like they did yesterday. They shoved everybody to one side, and then all the witnesses over to the other side.
Which is bullshit.
Yeah. So yeah, there was nobody in there but me. I think 3 other people that kept running in and out, but the rest were all fucking security guards, CPD, sheriff, undercovers.
Huh. So that many though. How many did you say total?
There was at least 13, and if you wanted to, at least 13.
At least 13 cops, and 6 of them were TPD?
Yeah.
All right. If I would have known that, I would have been there.
Yeah, but his, like I told you, man, and I'll tell everybody else, I just had a conversation with him, his lawyer, and his lawyer he's not going to be able to help Lane. So, and he's all worried about, right now he just had twins, so he's got 6 kids that he's, you know what I mean? So his head ain't in this game right now through this case.
Yeah.
So.
Oops. I was trying to get you set up here. Put you on my stick here. He hung up. All right, let me turn the fans off. So I got good ventilation in my grow room. Let me turn the fans off so I can get him back on the line. Here he is. Hey, you hung up on me.
I didn't know. He just
Oh.
died.
Yep. All right. So anyway, so his lawyer don't have his head in the game. You saying, or he's got
Yeah.
yeah.
Yeah, he's not in this game, man. He's double thinking his fucking this case.
Yeah.
So, but yeah, they're still digging for more charges.
Of course.
So
Well, now he can't go on YouTube anymore, so so we won't be able to make any more charges that way.
yeah. See, but that's why I just asked Dick right now walking out, hey man, so what's gonna happen to all these people that are making these YouTube channels now? Are you guys coming after all of us? So
What'd he say to that?
he just kind of, that look Dick gives, like he can't say nothing.
Yep.
But yeah, it was funny though. I was standing out there talking to you, and I was acting like I was filming them and shit. And they pushed Shannon and Paul to the fucking like, how the courtrooms are, that little white little pedestal they got there.
Yeah.
Pole.
Yeah.
They pushed them into the doors, and everybody started leaving. So where did they go? They shoved them out the back door.
They had yep.
So,
All them
yeah,
government guys, they go down the secret tunnel.
Yeah, you go out the back. You go into the courtroom, into the chambers, and then you disappear. You know what I mean? It's like, she's playing this role of being scared pretty fucking good, man.
Yep.
So.
She shouldn't be a public employee.
No, sir.
That's what I have to say about it.
So yeah, now you got, you kind of question it. If they're really doing this over public information, so what, are we all going to start publishing, the government and that? Are we all going to start getting charged now for harassment? So.
Yep.
But yeah, this is all a corrupt system. They're all in this together. This is all planned out, and they are violating his rights.
Yep.
So,
Yep.
But all right, man, I got to get out of here.
All right.
Things to do, and I hope it all helps out with the chat, man. So.
Yep. Now, yeah, it gives just gives a little bit of foresight to what happened in the courtroom. I should have went there if I would have known there was going to be. Last time I went, no TPD showed up at all. Yesterday, not one TPD was there.
Yeah.
And that's who I'm there for. And then they're the ones that arrested him, the week before. And I wish I was there then.
Yeah.
I like hanging out with my buddies.
I hear you there, man.
All right.
But yeah, it's I don't know what to say, man. It was all feelings, and he hurt my feelings and posted this and posted that. You know what I mean? But
yep, the feeding police are really big in Tucson.
Yep. But yeah, there's a corruption all the way, man. Everybody's involved.
And the worst.
They even said when I first got here that I think it was his lawyer that he says, yeah, every lawyer is watching this video right now, or they're going to watch this hearing.
Yeah.
So, but I don't know. Just gotta wait till the next one, see what happens.
Yep. All right.
All right, man.
All right. We'll see you later.
All right, later on, man.
Bye. Yep. Merb probably will be going on. I ain't watched any of Mer's stuff for probably 5 years. He used to talk a lot of shit about me back in the Leon Valley days. But I really ain't. Matt and Shannon Walker. You're now a moderator, Matt and Shannon Walker. I don't know if that's really you. Lane Myers is a bad dude. Like corn pop. Whatever that means. All right, Matt and Shannon Walker. That's a good YouTube name if you're a troll bootlicker. Because I have history with Matt Walker, as probably most people know. He's Vinny. He's Vinny's supervisor. So Vinny was the first guy that's on the case that I'm still going through with the one on Prince Road with the guy, the corrections officer with no shirt and pierced nipple rings come up and slapped the phone out of my hand. Assaulted me on camera and knocked the phone in the middle of Prince Road, which is a very busy road. James Freeman is my uncle, Biscuits and Gravy said. Is Uncle Freeman still in here? I ain't been looking at this chat for a while. But Matt and Shannon Walker, you're now a moderator. So don't say anything bad because people's going to... I might have to mod I Am a Jackpot here, so maybe he can... Now, he'll probably like you, though. Can't do that. If it really is. But I'm pretty sure that's somebody's stage name that's being funny. I don't think it's the real Matt and Shannon Walker. If it was, welcome in. You can come in here and post Lane Meyer's address, and then we can get injunction on you. And he didn't even post her address. He only posted the address of where she worked, which is public information. He never posted her home address. Let's see, James, you in here? Yeah, there he is, lurking. So anyway, Lane Myers is going down. I mean, that just sucks that someone can get charged for what, just talking about someone on YouTube. But like I said, he's going to save the government a lot of money because them 9 hours, they watched the whole thing. Probably 50 of them are government employees on the clock, just like Dick Tracy. Dick Tracy watches all our stuff. He never comments. Dick Tracy's probably in here right now. Dick Tracy told me he's trying to get the judges to make a contempt charge on me for filming out in the courthouse. The last time I was live, he was telling me that. Dale Hess says, James Freeman is my baby's daddy. Cool. Welcome in, Tal Tracy. Oh, you must have commented real fast because I made you a moderator fast. Say something again. I made you a moderator before you came on, I thought. Say something again, Tal Tracy. Make sure that's working. You should be a moderator. You should be blue. Come on, Tal, say something. I admire you, Tuck. Well, thank you, Torque. Are you just saying that because you're a troll or you really mean it? I like the way you think, James Freeman. Come on, Tal Tracy. Are you in here? Am I blue? Next time you talk, you will be. Everybody's blue. Not like the blue line in the flag, though. Mile High Trucker, you should be blue. Show me how to grow pineapples in the desert. Actually, I do it in my grow room. And if you look right there, it's that's hydroponic. All my pineapples are hydroponic. Oh, okay, with the exception of that one right there. That one there is dirt. Cocoa core and perlite. That's a banana tree. But the pineapple, all these bananas, they're in them crates. That's all hydroponic. And this whole thing was hydroponic, but when I first started, but I had to go back from it, and I'm doing hydroponic stuff now, but not in this little grow room. It takes more room. But right there's my my swamp cooler that cools the room, drains into that bottom tub right there, and and I put the chemicals in it. Sometimes I put some in right there, but the pineapples don't take much hydroponics chemicals. So I put the chemicals in, so it goes through. Oop, got tangled up here, guys. So, oops. All right, got the bottom tangled up. Okay, as it goes through all these pineapple and banana containers, then it goes out that line and then into my tank, and that's where I add my chemicals. And then I have a clean machine that pumps out every 8 hours. Every 8 hours, what happens is it dumps the water in there, then I add the chemicals, and that's how I water all my plants. So I use, so right now I'm getting ready to switch over to bud. So here's my chemicals. Oops. You guys flipped around, uh-oh. You guys dizzy? I use this big bud. This is full. It's hard to even hold up here. But that's over a gallon. How much is this? 1 gallon. 4 liters. So anyway, I'm getting ready to do that because I'm getting ready to bud these. As soon as they reach, they grow about another third. So I'm about 2 feet from the ceiling. Remember, you can't grow buds this high when you're doing only lights. If you look, my light just came on. So you can't do that with the lights, because the lights, even these big metal 1,000-watt halides, metal halide and sodium vapor lights like I use, the sodium vapor one's in now because I'm getting ready to switch to bud. But even them lights, they only reach down about 3, maybe 5 feet, so you can't grow that big. But the sun doesn't matter. That's why I do it in a greenhouse, because I can go all the way up to the ceiling. I'm going to be shutting this light totally off right now, and then it's going to go into bud, because these ain't auto buds. These are all they're from feminized seeds, these ones here. So anyway, they're really bushy, as you can see. It looks like I got a lot of plants in here, but there ain't that many. It's just 12 here. And not even 12. I think there's 11 because I took one of them out. But anyway, so you can't grow plants this tall using just natural light. I mean, just artificial light. Now, outdoors, you can grow up 14 to 20 feet, but you, the grow man, but I'm about the only one that's actually doing a hybrid system, outdoors and indoors. And if you look at my light right there, it's as high up as it goes. So the only thing I can do now when it grows into there is shut it off. And that's what I'm getting ready to do now. I'm going to be going into bud. I've been cutting the light back. You know, I was going over 16 hours total, or 18 hours total in the beginning. And then I switched the bulb. Now I'm into about, what, 15 hours. I'm going to drop it down another hour. Then maybe in 4 days, I'm going to turn it all the way off, because we're now in the end of March. So we're going to get 12 hours of light just from the sun. And the reason I can, and I tested growing, I can bud right in the middle of July. Last year I tested it because of this wall. This wall right here keeps it from, you know, that in there, the sun comes in on the east side. But the whole west wall is blocked, so that's why I can bud without, you know, without making it dark or anything. All I have to do is turn this light off. Then I can go 2 months of budding without no electricity at all from the light. And these lights are expensive to run, you know. So I've been growing outdoors for years, and 12 foot is the tallest I've seen. Cool. So I'm going to be growing more outdoors soon, and I'm doing hydroponic outdoors. I've been experimenting at other places and doing outdoor hydroponic. Not many people do outdoor hydroponic, but I got about 12 of these tubs already set up at another location, and I'm actually, I can grow up to 72 plants is my max, because I am a caregiver. So I can caregive for 5 people, 12 plants a person with a medical card that lives 25 miles away from a dispensary. You can't grow unless you're 25 miles away from a dispensary with a medical card in Arizona. So that's one of the problems. So, but I can caregive for up to 5 people, which is 60 plants, and then I can grow my 12. So I can grow 72 plants. You don't have to grow no 72 plants when you're growing big like this, because you get good yield. But a lot of people grow only 12 to 12 to 15 inches high, and then because the lights don't reach down as far, then they start budding. So them guys don't get much more than an ounce a plant, you know, when they're growing a whole bunch of plants about 12 inches tall, you know, or up to 2 feet. And a lot of people grow that way, but when you only can grow 12, it's not as good that way, because you have to grow them taller. That's why I grow in an outdoor grow room. That's why I built this grow room. I built it in 2020, about 2 months before it became legal, because I was betting on it was to become legal. If it didn't become legal, then I was just going to grow as a caregiver and not for myself, you know, because I could still be a caregiver for other people, but the other people I'm caregiving for has to be 25 miles away from a dispensary, you know, and that sucks in Arizona that you have to do that. But that's why the investor-driven initiative, and that's a long subject, because I've been working on the legalization of marijuana for a long time, 30 years, you know. It's been a long haul. In 2010, we was allowed to do it medically. In 2020, we finally got the adult use passed. So anyway, guys, I'm going to get out of here. Let me read here. Any questions? I ain't been reading the chat at all. Freeman, you still in here? Freeman don't watch long, boring chats. He likes people getting tased. If I'm not getting tased, he's going to leave. Uh-oh, you're still lurking. Uh-oh, I'm not getting tased. Since Freeman's still in here, I'm going to have to find an electrical outlet and stick something in it, so it makes him, you know, keep him watching. All right. welcome in, let's see here. Welcome in. Can't even read that very good. That light is shining right in my eyeball. But anyway, you're now a moderator. You unplug that light with your hands? No, that thing gets real hot. That light's on a timer. I don't unplug it with my hands. When I do take the bulb out, I turn it off. It ain't hot at all, but you don't touch that when it's hot. That is one hot bulb. So, but no, I'm on a timer, guys. Right here. It's a timer. And that's why I just now started. So I just now started right here, guys. That's hydroponic cloning. So these are 2 hydroponic cloning machines. So before I go into bud, I make kids out of the mother plants here before I go to bud. So I don't really keep mother plants going. You can keep them in veg state for a couple years, but I don't do that. I use the mother plants, and then because if you keep doing it too much, about 2 years or so, it starts going down. Hey, Freeman just went. Entertain me, Freeman says. Yep, go stick my something in a light socket. I could use that one because that has a ballast hooked up to it. If I pull the light bulb out of there, I'll get a big jolt. But if you notice there, that light's on a tracker. It's moving back and forth. And on these 1,000 watt halides, they're so expensive to run, you want them on a tracker. So I can do all of the plants. And then the daylight does it all day long. And then the only reason I have it coming on this early right now is because I'm cutting it back to go into bud. And this here is a sodium vapor. If anybody knows about growing, when you go to bud, you put in the high pressure sodium, So that's why I got it on with the sun a little bit. The sun's getting ready to go down. In about another hour and a half, it'll be dark. How long does it take the pineapple to fruit? 2 years. Pineapple takes 2 years to fruit, and it can't go below 50 degrees. So I am unsuccessful growing a pineapple outdoors. I tried it, in different ways. I tried to keep it warm other ways, but I never do it. This is the only place I was ever able to do a pineapple because this never goes, it probably never goes below 60. So, Crosco, welcome in. I have a friend who's a lawyer named Crosco. He died. But yeah, pineapples take 2 years. You have to keep them. If they freeze once, you lose it. That's why you only get it in Hawaii. And if anybody knows about earth ships and stuff, that's why I want to start building earth ships, that it might not be the tire type, but the facing south, and then the using the sun to heat up your place, and then keeping your, then you can grow pineapple and banana. They grow it in New Mexico, like Taos, Michael Reynolds, and I do want to start growing tropical stuff, but this room's not big enough to do too much stuff. I actually have to, if anybody wants banana trees and live in Tucson, let me know. These banana trees are getting too big to live in here. I got to get them out. Pineapple only go up about 4 foot tall, but pineapple or the banana trees are already over 7 foot tall. And I only got an 8 foot ceiling. So I have to keep cutting them back. I'm waiting to find somebody that can take them because I need to put them where it goes at least 15 feet up. Time for evening chores. Thanks for the live, Tuck. Peace out. All right, Brent. Grow coffee. I don't care much about coffee. I'll leave that to the Colombians. I don't think anybody grows coffee in America. I don't think there's any coffee companies. Maybe Hawaii. I did hear there was something in Hawaii. All right, guys. Organic weed is the best. That's what this is. It's organic. Dig a basement halfway. Yep. Yes. A basement and earthship. I've been thinking about that too. Because if you go down about 8 feet and then go up 8 feet, then you can grow 16 feet tall. Yep. Earthship and a basement. Yep. Yep. I agree with that. And I am experimenting with that stuff, guys. I got property out in the county. You know, I have to live now in Tucson because this is where my business is. I'm an air conditioning guy and I can't, I used to live out way away and drive to Tucson every day, but that takes, I was about 2 hours away, so that took 4 hours round trip when I did that. But I did like it. I used to live in Turkey Creek up in Chiricahua Mountains, and I loved it out there. But there just ain't no jobs out there. Anybody ever been to the Chiricahua Mountains? That's where Cochise and Geronimo, that's their territory before they threw them in jail. All right, guys, I'm going to get out of here. Is it any good? Are you talking about the weed? This here is 100% indica, and I got a couple 100% sativas. And I've never tried none of this stuff. They came from seeds. I've been doing clones. This is the first batch that I did from feminized seeds. I'm a big clone guy, and I clone them. I like cloning. You know, I like experimenting with cloning, and you can have as many clones as you want, you know, and then just pass them out before they get roots. But it takes about 3 weeks, sometimes a month to get roots. So in a month, anybody wants plants and live in Tucson, let me know. I'll have plenty of babies. So anyway, guys, I'm with Veterans United for Cannabis, and we spread out clones to veterans. We'll give them to anybody that wants them. You know, we spread it as long as you're 21 and older, you know, or you're have a medical marijuana card. Either way. But all right, I'm going to get out of here, guys. This is a 2-hour live stream, so I'm going to get out of here. Thanks for coming in. See you later.